Hello and good morning friends, welcome to the CEC-UGC live lecture. Dear friends, as you know that in our previous session we talked about procedural requirement for obtaining patents in India. This is one of the topic we are carrying under our series on general course on intellectual property rights. Yesterday we discussed about how to apply for or how to file for the patents, that is how one can apply for the patents as well as where one can file for the application, file for the patents. And today also we are going to carry the lecture forward, yesterday's lecture forward, that is on procedural requirement for obtaining patents in India. And today we are going to discuss what is the manner or how one can formulate or file application for patents. For this, dear friends, today we have again with us in our studios Mr. Ashwani Sewal. Mr. Ashwani Sewal is Assistant Professor in Faculty of Law, University of Delhi. So without wasting any time, I would like to welcome our guest, Mr. Ashwani Sewal. Mr. Sewal, welcome to the reset lecture.
Thank you very much, Gitika. Good morning, viewers. Well, our today's discussion would revolve on how to formulate the application for obtaining the patent. We, in yesterday's discourse, discussed who is eligible to file the patent protection, and we have understood in our today's discourse when to file the patent application and where to file it. The office where one needs to approach and file the patent application. Territorial jurisdiction we understood in our previous discourse. Today I am going to finally conclude this topic with my today's discourse by telling the viewers about the formulation of the patent application. It is very important as to how one is formulating the patent application, because if one is not formulating the patent application properly, if there are some discrepancies in the filing of the form, then in that case the patent office may turn it down or may ask the patent applicant to revise the application, though that may take some time. Will take long time to correct or rectify the application discrepancies. So it's better to understand for all of you to first of all know what are the formalities and what are the particulars to be furnished and provided and procured in the application while filing the patent or approaching the patent office. Well friends, in yesterday's discourse I told you that Form 1 of the Patent Rules 2003 is essential to be attached with your application for obtaining the patent. As per section 7, it is aptly clear by the reading of subsection 1 of section 7 that there would be one application for one invention. There shall be one application for one invention. It means one cannot file one application seeking protection on two inventions. That has been discussed by me previously, in my yesterday's discourse. Another important thing that we get from the reading of section 7, that to my understanding is very important, that one needs to pay the requisite fee and file the application in the prescribed form. And as I told you in my yesterday's discourse, that the form has been prescribed under the Patent Rules 2003. Patent Rules 2003 contains many forms. Out of those forms, form number 1 of the Patent Rules 2003 is the form to be attached with the patent application, and the application shall be filed on form number 1 along with the complete and provisional specification. Well viewers, section 7 subsection 4 made it clear that your application for obtaining the patent will be accompanied by provisional, either the provisional or the complete specification with the prescribed fee. So the fee has been prescribed under the schedule number 1 of the Patent Rules 2003, and the provisional and complete specification and the descriptions and the contents of the provisional and complete specification are given under section 9 and 10 respectively of the Patents Act 2003. So in our today's agenda, we will be discussing all these provisions and seeing the language of all these important rules and provisions threadbarely, so that we can understand how to file and formulate the patent application. Well friends, yesterday I tried to show to my viewers the particulars to be filled in the form number 1 as required by the Patent Rules 2003, wherein it is aptly clear that the name of the applicant, the name of the inventor, title of the application, and then other attachments in the form of drawing or model or sample or something like that, they are to be furnished by the applicant for seeking the patent protection. If he wants to make the application properly, then he needs to furnish as many documents as possible to vindicate his claim and to vindicate his invention, so that his invention can fetch the patent protection from the patent office conveniently and easily. So no obstruction would be placed by the patent office if your application will be full-fledged and will be immaculate, spotless application involving no discrepancy at all. Well friends, if you jump to the slide number 1 as on your TV screen, it reads that the patent application shall be filed on Form 1. As highlighted by me, Form 1 is the form to be attached with the application along with provisional / complete specification with the prescribed fee as given in first schedule at an appropriate office. So see, in this first sentence, it is clear that there is a requirement to file the application on form number 1 with the provisional or the complete specification with the prescribed fee, and the most important thing is at an appropriate office, at an office which does have or possess the appropriate jurisdiction to entertain your application. However, a provisional specification cannot be filed in the case of convention application or in the case of PCT application. That is quite clear that this provisional specification is to be filed with your application only in the case of ordinary application, or maybe in the case of division application, or in the case of the patent of addition application. But in the case of the convention application and in the case of PCT application, provisional specification is not required to be filed. Only complete application will be, or complete specification will be sufficient. Well friends, as I told you in the yesterday's discourse, that the fee to be paid for obtaining the patent protection to the patent office is provided under schedule number 1, and schedule number 1 prescribes a fee for all the procedures. Every minute procedure details are given in the schedule number 1. Against those procedures, the fee is also mentioned. For a normal individual, the fee is mentioned, as well as for an entity or an organization or a joint application, fee is also mentioned. There lies a distinction between the fee to be taken from the natural person and the organization, entity or the division application. That demarcation has been beautifully made in the schedule number 1. This fee generally remains a normal fee if your application does not exceed pages 30 in number. If your application is less than 30 pages, in that case normal fee will be charged or levied on the applicant. But in case if it exceeds 30 pages, or if in case your application is seeking more than 10 claims, in that case the fee will rise accordingly as per the schedule or listed in the schedule. So one needs to take care as to how many claims one is making in the application. Another important thing that one needs to see, how many pages applications he is going to file to the patent office. If it exceeds 30 pages, in that case extra fee has to be levied, and for that matter one is supposed to refer to the schedule number 1 to see how many extra bucks one is required to pay or need to pay in case of extra number of pages filed by the applicant. Well friends, let us move ahead and see what is the formulation of the patent application, how to formulate it, how to file it. We will need to see under this head what would remain the content of the application. If we talk about the content of the application, as we all know, application for grant of patent in form number 1, and form number 1 has been already discussed and threadbarely analyzed by me in my yesterday's discourse, wherein we saw that there are certain particulars to be filled by the person seeking the patent. Then applicant has to obtain a proof of right to file. See, when you file the patent application, you need to prove the proof whether you are entitled to file the application. If in case you are a assignee or a legal representative, if you are a true and first inventor, then you are not supposed to file any kind of a proof of the true and first inventorship. That will get proved or assumed by the patent office. But in case if you are not a true and first inventor and you are just an assignee or what we call it a mere legal representative of the true and first inventor, then in that case you have to show some proof of right to file. I mean some kind of a transfer of the right to file the application if given by the inventor to you, that has to be adduced with your application to the patent office by the applicant. If he fails to do so, then in that case his application has to be revised or will be asked to be revised, ordered to be revised by the patent office. Then the another important thing which also makes up content of the application is the complete and provisional specification, and the format of the complete and provisional specification is provided in form number 2. Well friends, this provisional and complete specification and its contents are provided under section 9 and 10 of the Patents Act 2003, and this form number 2 of the Patent Rules 2003, they are to be read together to understand and comprehend as to how to make the complete or the provisional specification. As I have discussed previously that this provisional and complete specification is a techno-legal document. It's a kind of a document which comprises some legal formalities or legal issues in it, or involving some technological information in it. This complete or a provisional specification and its contents are very important for the patent applicant while filing the patent application, because here in form number 2 he needs to provide a title to his application. He is supposed to name the application indicating the kind of a claim he is making, wherein he is supposed to provide kind of a preamble to the invention. He is not supposed to provide every meticulous detail about the invention, but a preamble sort of a thing is required to be proved or kind of a put over there in the form number 2 while filing the complete and provisional specification, and the rest of the contents which we will see while reading section 10 of the Patents Act. Another thing that also makes the part of the content of patent application, one needs to state and undertake that this application is filed in a proper format, and form number 3 has to be adduced with your application, where you will undertake or give certain statements. Form number 3, I will show you the form number 3 on the screen later. That form number 3 is required to be adduced and attached with your application, wherein one will be stating and undertaking some very important informations and particulars. If he fails to do so, his application may get turned down by the patent office. Well, if we proceed ahead friends, another important aspect that one needs to provide while filing the patent application, one has to declare as to inventorship. That is in form number 5. One needs to declare as to inventorship, that has to be filed in form number 5 for applications accompanying a complete specification or a convention application or a PCT application designating India. One needs to declare that he or she is the inventor, or if she is not the inventor, then in that case in the form number 5 one has to prove that he is the legitimate assignee or the legitimate legal representative of the true and first inventor. Another thing which makes the content of the patent application, power of authority in form number 26 has to be filed through a patent agent. This power of attorney or authority basically gives a power either to the patent agent or to the filer of the patent application the authority to file it before the patent office. So this power of authority and its particulars are to be provided in form number 26. So friends, there are many forms which are to be referred by the patent applicant or has to be filled by the patent applicant while filing the patent application, and there are certain declarations are to be made by the patent applicant. If he fails to do so, then that particular application will not be an immaculate application, will have certain discrepancies, and rectification for the same may be asked by the patent office before entertaining the patent application. Another important part or thing that becomes content of the patent application, the priority document are to be provided. If you are seeking the priority or if you are claiming the priority, then in that case priority document is required to be furnished in the following cases. In the case of the convention application and in the case of the PCT application, this priority document may be filed along with the application or before the expiry of 18 months from the date of priority, so as to enable publication of the application. Friends, I would like to emphasize on this part that one needs to provide the priority document along with the application or before the expiry of 18 months from the date of priority, as to enable the publication of the application. If one does not file the priority document and if he claims the priority either at the time of making the application or before the expiry of 18 months, then he should provide or he should adduce the priority document claiming that he has got the priority as he is a first to file in terms of time vis-a-vis to other inventors as far as that particular subject matter is concerned over which he has sought the patent protection by filing the application on priority. Well, some more things that makes the part of the patent application while formulating the patent application, that every application shall bear the signature at the applicant in the application or of the authorized person or of the patent agent along with name and date in the appropriate space provided in the forms. Well, this is also important when one files the patent application. If the true and first inventor is filing himself, then he needs to sign the patent application. If he forgets to sign it, then in that case it will get remanded back to the applicant and he has to furnish it again, refurnish it I mean. If the authorized person is filing the patent application, then the authorized person is supposed to sign it and he also is supposed to furnish the information who is the true and first inventor of the application or the invention. And if the patent agent is filing, then he will sign the patent application with his name and provide the date in the appropriate space in the form. And the specifications are also to be signed by the patent agent or the applicant with date on the last page of the specification. The drawing sheet should bear the signature of an applicant on his agent in the right and bottom corner. See friends, when you file the patent application, all these details though seems small or are small prima facie, but they are very important. Signing the patent application, then signing the specifications. If it is a provisional specification of your application, you need to sign it at the end of that specification. And the drawing sheets, if are attached, it's not mandatory to attach the drawing sheets, but if the drawing sheets have been attached by the patent applicant for making it convenient for the controller to understand the patent claim, then those drawing sheets are also supposed to be signed by the patent applicant or the patent agent on his behalf or the authorized person on his behalf. Another important part of the formulation of the patent application, if your claim contains or if it pertains to a biological material, then in that case the applicant is required to submit the permission taken by the applicant from the National Biodiversity Authority. Well friends, this point is very important. The third point on the screen requires the patent applicant to furnish the permission sought by him or obtained by him from the National Biodiversity Authority, which he needs to obtain from the National Biodiversity Authority if in case his invention involves a biological material in it or if it is an application pertaining to a biological material. So that is very important and that has been made mandatory by purview of section 6 of the National Biodiversity Authority Act of India, which requires the applicant to obtain the permission in case one seeks to obtain the intellectual property on the invention involving a biological material in it. And that condition has been put over there to make the things transparent and to preclude the inventors from taking away unauthorizedly the biological materials available in our biodiversity. So that's a kind of a check put by the Biodiversity Authority that whosoever will require to obtain an intellectual property protection on an invention involving a biological material, that person, that individual or the organization or the entity is required or needed to furnish the permission taken by him or that organization from the National Biodiversity Authority for using that biological material in his or her invention. So that is one of the important aspect to be taken care of by the people, or especially those people, I mean those scientists and companies and ventures involving research including biological materials taken by the researchers from the biodiversity of the India or from the flora and fauna of the India. Well, the another thing that also makes an important part of the application, that the form of the application shall also indicate clearly the source of geographical origin of any biological material used in the specification wherever applicable. I mean, according to this requisite, one needs to furnish the information of the geographical origin, I mean from where one has obtained the biological material while using it for making the invention which involves a biological material in it. Well friends, when we come to section 10 of the Patents Act 1970, which provides the contents of the provisional or the complete specification. So by language of section 10, it is pretty clear that every specification, whether provisional or complete, shall describe the invention and shall begin with a title sufficiently indicating the subject matter. See, as shown on the slide, section 10, this is the verbatim language of section 10 reproduced over here, friends, and it requires the applicant to describe the invention and shall begin with a title sufficiently indicating the subject matter to which the invention relates. I mean, this is one of the requirement posited by section 10 for filing the complete specification as well as for the provisional specification. See, this requirements or these requirements of section 10, they are applicable to both the kinds of applications, on the provisional as well as on the complete specification. Another requirement that has been posited or that has been put by the section 10, that if in case the controller requires you to attach the drawings of your invention with your application, then you need to furnish those drawings with your application, or you have to supply these drawings for the purposes of your specification and for making it clear in both the cases, in the case of the provisional as well as in the case of the complete specification. The third clause of section 10 reads that if the controller requires the applicant to adduce the model or a sample of the invention or the claim, then you have to supplement your application with that model or the sample illustrating the invention or alleged to constitute an invention. If you fail to do that, then in that case, if it is directed by the applicant and if you fail to do that, then in that case the controller may ask you to refile the model or the sample required illustrating the invention or alleged to constitute an invention. Such model or sample shall be furnished before the application is found in order for the grant of a patent, but such model or sample shall not be deemed to form part of the specification. See friends, in the case of the drawings will be deemed as the part of the specification, but the model or the sample provided by you to supplement your claim of an invention, that model or a sample will not be deemed as the part of the specification. Well, for the fourth subclause of section 10 is only applicable on the complete specification. The preceding three subsections of section 10 are talking about the contents to be furnished in both the cases, in the provisional as well as the complete specification. But this subsection 4 of section 10, it is applicable only for complete specification. It is giving a fair idea about the contents to be furnished in the case of complete specifications. Let us threadbarely see what all are the contents or will remain the contents of the complete specification. The complete specification shall, friends, the word shall is used, which makes it mandatory for the applicant to file the complete specification in the manner provided herein. that the complete specification shall fully and particularly describe the invention and its operation or use and the method by which it is to be performed. Well, when you file the complete specification, you have had enough time to come out with the best mode known to you. You have had enough time to know as to how your invention is workable and working. So you need to describe all these things in the complete specification fully, and particularly the invention over which you are seeking the patent protection and the operation or use of your claim and the method by which it is to be performed. All these informations are to be provided in the complete specification, and you need to disclose the best method of performing the invention. What would remain the best method of performing the invention? Well friends, I would like to tell you one important information here, that this section 10 or subsection 4 requirement is the requirement in consonance with the philosophical foundation of the patent regime. See, patent regime promises openness of the technologies or openness of the inventions, and this section 10 through subsection 4 makes it mandatory for the patent applicant to describe the invention fully, to disclose it fully, and disclose the best method known to him of the working of or the performing of the invention which is known to him and known to the applicant. That is how the patent regime ensures the disclosure of the patent application as well as the working and the best method known to the applicant about the performance of that particular invention over which he is seeking the patent protection. Another important aspect that one needs to specify while filing the complete specification in consonance with the requirement of subsection 4 of section 7, that your application, which is a application for obtaining the patent through the complete specification, must end with a claim or claims defining the scope of the invention. In a very precise manner, one is supposed to tell as to what is the scope of his or her invention for which protection is claimed. He needs to tell the scope, he needs to disclose the best method, he needs to fully and particularly describe the invention and its operation or use and the method by which it is to be performed. And then finally, that has to be accompanied by an abstract to provide information. Well friends, while filing the patent application and vindicating or supporting your patent application with the complete specification, you have to be very cautious about complying with the requirement of subsection 4 of section 10. This section 10 through its subsection 4 requires the patent applicant to fully and particularly describe the invention, one thing. Another, to disclose the best method known to the applicant. Third requirement, to end the claim with the defining or with the definition of the scope of your invention for which the protection is claimed. And the fourth and the final thing, that it has to be accompanied by an abstract. Abstract will comprise the information about the invention, will comprise the meticulous information provided by the applicant for obtaining the patent protection by the patent controller. So in the abstract, that abstract has to be very precise, but all the important substantive informations are to be furnished or will remain the part of the abstract. That has to be taken care of by the people seeking the patent protection. Well friends, another important point that has to be comprehended by all the viewers while understanding the procedural formalities or procedural aspects for obtaining the patent, it is about the publication of the patent application. Well friends, see, at this juncture I would like to recapitulate 2-3 things for all my viewers, that you have now understood who is eligible to file the patent application. See, one who is the true and first inventor is eligible to file the patent application. One who is an assignee of the true and first inventor is eligible to file the patent application. One who is the legal representative of the deceased true and first inventor is allowed to or entitled to file the patent application. Where to file, we have seen that section 74 of the Patents Act 1970 tells that there is a head office or there are branch offices of the patent office. You have to identify the appropriate patent office where there lies the territorial jurisdiction of your state. You can go and approach that patent office and file the patent application. When it comes to how to file it, we have understood now that there remains a particular format or the forms for obtaining the patent, and in that particular fashion you are supposed to articulate your application for obtaining the patent. That articulation has to be done in consonance with the Patent Rules 2003 as well as in consonance with the Patents Act 1970. I mean, some of the provisions of the Patent Act 1970, especially provision number 7, 9, 10 and patent rules, especially form number 1, form number 5, 2, 3, 6. These are to be taken into care or consideration by the applicant while formulating the patent application and approaching the patent office. The next thing that comes after filing the patent application by the entitled person at the appropriate office of the patent, it is about the publication of the patent application. Well friends, I would like to tell you that in the cases of the intellectual properties, the process and the procedure for filing the application for obtaining the IP differs from IP to IP, I mean from intellectual property to intellectual property. If it is a case of a trademark, then in that case the trademark board suo motu publishes your trademark application for obtaining the registration. But in the case of the patent, friends, it's a complete contrast vis-a-vis to the procedure in the trademark law. Here in the case of the patent, the applicant himself has to apply if he or she wants to publish or get his work published in the journal of the patent at an earlier date before, or say at an earlier date of the prescribed date or prescribed period, then he needs to approach the patent office with the request of the publication, with the request of getting it published. If you see section 11 and its language, it makes it aptly clear that an application for patent shall ordinarily be open to the public for such period as may be prescribed. That no application for patent shall ordinarily be open. See, the rule is that no application for patent shall ordinarily be open to the public for such period as may be prescribed. It means during that prescribed period, or that period has been prescribed under the Patent Rules 2003, during that period no application will come into the public domain or will be given an access to the public through the publication. But in some situations, or say if the patent applicant requests to the patent controller to publish his patent application before this prescribed period, then there is a procedure provided over here under the clause number 2, which reads that the applicant may in the prescribed manner request the controller to publish his application at any time before the expiry of the period prescribed under subsection 1, and subject to the provisions of subsection 3, the controller shall publish such application as soon as possible. Well friends, as per the procedure or the rules provided under the Patent Rules 2003, the patent application does not get published for a period of 18 months. I mean, during these 18 months the application does not comes into the public domain or fall into the public domain. It remains with the patent office, and the patent office does not let it open. If the patent applicant requests to the patent office to publish it before or within those 18 months time period, then they will have to request under 11A subsection 2 for getting it published at earliest. What is the effect of getting it published at earliest? Friends, when it gets published, it is giving you certain advantages, and that advantage is very important for every patent applicant, because with your patent application publication you get certain rights to claim damages. You don't get right to sue the infringer of your work, but you get a right to claim the damages if somebody infringe your work. That is why it has been made kind of lenient or flexible for the applicant to get it published before these 18 months time period, as written over here under 11A subsection 2. Well, friends, another important clause of 11A is clause number 7, which reads, on and from the date of publication of the application for patent and until the date of grant of a patent in respect of such application, the applicant shall have the like privileges and rights as if a patent for the invention had been granted. So see, this is the effect of getting it published at earliest or on a early date before the prescribed period. The advantage is mentioned under subsection 7 or clause 7 of 11A, that it would be deemed as if that the patent has been granted on the date of the publication. And when your patent is granted, it means you get certain privileges, you get exclusive right, you get some sort of monopoly, you get so many things. I mean, procedural, what we call it, I mean, sorry, not the procedural, but the enforcement of the patent in case of the infringement comes at your hand or comes at your disposal if you get the priority or if you file it at earliest. Moreover, if you get it published at earliest or before the prescribed period. I will exemplify it by giving you a simple example. Suppose inventor A files the patent application and the patent office, as per the patent rules 2003, needs to publish it or is supposed to publish it within 18 months of time period, or after 18 months of time period, I mean. Before that prescribed period, the patent office will never publish the patent application. This inventor A does what? He approaches the patent office, requests the patent office by invoking his promise given to him by the Patent Act 1970 under 11A to get his work published before the prescribed period, and he got it published on the 4th month or within the 4th month of the filing of the patent application. So when he gets it published on the very 4th month of the patent application filing, his patent application will be deemed as granted on the same date when he got the permission from the patent office of the publication and it got published. So from that date onwards, it will be his work, he will have some privileges over others, he can sue the person for damages, he can enforce others not to make use of his work. So there are certain benefits that one gets when he or she files the patent application and gets it published on a proper time. I mean, before the prescribed period of 18 months. Well, friends, another thing that we need to see when it comes to publication of application, there is rule number 24 which tells or which gives us an idea that the prescribed period for an application for patent is 18 months from the date of filing of application. So when we read 11A, we need to read it along with rule number 24, which gives the prescribed period of 18 months from the date of filing of application or the date of priority of the application, whichever is earlier, provided that the period within which the controller shall publish the application in the journal shall ordinarily be 1 month from the date of expiry of said period. Well, when you request to the controller for getting your work published before the prescribed period, usually it happens that the application gets published in the journal ordinarily within 1 month from the date of expiry of said period, or 1 month from the date of request for publication under rule 24A. So within 1 month of the request, the patent controller is supposed to or bound to publish your work. If it does not do so, then you can remind the patent controller about the publication and your request, and he will accordingly proceed with the publication. The patent office publishes the application in the official e-journal. There comes a e-journal ordinarily within 1 month from the date of expiry of 18 months from the date of filing of the priority, whichever is earlier. So within 1 month of your request, the patent controller will make it published in the e-journal that comes from the patent office, and that will be accessible by the normal public, by the viewers, or by anybody interested to see the claim made by the inventor or the applicant on that subject matter. On that basis, on the basis of the publication in e-journal, one can approach the patent office for the pre-grant opposition for any kind of objection if one sees or one feels like objecting of the patent application. Well, as I told that with the early publication and with the getting it published at an earliest, you get certain benefits, and the benefit is provided under 11A clause 7, which says that it would be deemed as if it was granted on the date of the publication. So to my understanding, and friends, it is my advice to all the people who are seeking to file the patent and seeking the patent protection, to go to the patent office and request the patent controller for getting your work published as soon as possible, because from that day onwards, or from the day when your work gets published in the e-journal, you are deemed to own that patent on the invention, or it is deemed as if it was granted on that date. So it's better to get it published earlier instead of waiting for prescribed period of 18 months to cease or lapse. Well friends, a request for early publication may be made in form number 9 within the prescribed period, and fee of rupees 2500 by the natural person has to be paid, and fee by the legal entity to be paid is 10,000 rupees. The request for early publication will be considered if it does not pertain to subject matter relevant for defense or atomic energy. Well, I am skipping this portion, friends. Another important information that you must know, that where a request under A is made, the application is published within 1 month from the date of such request. That is also written under rule number 24A of the Patent Rules 2003, and form number 9 has to be attached with your application for getting your work published on early date before the prescribed period ceases. Well, what is the effect? As I said, you can claim damages from the date of publication. However, the patentee cannot institute a suit for infringement only after a patent is granted. He is eligible to institute the suit. He cannot institute an infringement action. He can institute the infringement action only after getting it finally or conferred the patent protection finally. Before that, he has a right to claim damages from the person who is infringing or contravening his patent. Well, another important point that one needs to understand at this juncture, that when you apply for the patent protection at the appropriate forum with the prescribed fee in the prescribed manner, and if your work has been published by the patent office either within the prescribed period or at an early date on your request, the next thing that comes, which is an important process part or part of the process of obtaining the patent, it is about the examination of the patent application. As you have got your work published, or maybe within the prescribed period they will publish it on their own, how to get the work examined? Who will file the request for getting it examined? Or the question should come to the mind of the reader or to the mind of the viewer, that whether the patent office itself will examine it on its own. See, when it comes to other intellectual properties, especially trademarks, the the trademark board itself on their own examines the examines the trademark application for the registration. But in the case of the patent law, the situation is little different, where the patent applicant himself requests the controller for examining the application. He has filed the patent application. He is done with all the formalities of filing and articulating the application. Now the most important part of the process of obtainment of the patent, who is going to examine the patent application and how the patent application is to be examined, on what criteria that application is to be examined. These are some of the questions that we will tackle in this discussion. Well friends, when it comes to examination, section 11B read along with the rule number 24B, and some forms are also to be comprehended or discerned by the person, form number 18 and first schedule. See, from the first schedule one comes to know about the fees to be paid for getting the work examined. Form number 18 is a form to be attached with your application for getting your work examined. And rule number 24B provides a time period within which the application has to be examined, the claim has to be examined. And 11B, which is a section under Patents Act 1970, this section 11B posits a requirement of request to be made by the applicant himself for getting the work examined by the patent controller. Let us move ahead. Well friends, an application for a patent will not be examined unless the applicant or any other person interested makes a request for examination. The request is to be filed in Form 18 with the fee as prescribed in first schedule. That is aptly clear from the reading of the language in your on your TV screen, that it is only on the request of the applicant or any other person interested in making the application that your patent application will be examined. Otherwise, it will not be examined. A request for examination has to be made within 48 months. That has been provided under rule number 24B of the Patent Rules 2003, that the request for examination has to be made within 48 months from the date of priority of the application or from the date of filing of the application, whichever is earlier. If no such request for examination is filed within the prescribed time limit, the application shall be treated as withdrawn by the applicant. So the thing to be noticed by the viewers, that within 48 months time period, you have to request to the controller of the patents to examine your application, your claim. They will not examine on their own. I mean, they will wait for your application to approach them or come to their office for 48 months. If you will not file the request for getting your work examined, in that case your application will be deemed as withdrawn by you, as if you have never filed your application, or you can say that you withdrew your application, you did not take further steps, because this is also one of the important step or a procedure for obtaining the patent protection, which we call request for getting the work examined by the appropriate authority. And when your request has been made and the request has been entertained by the controller makes a reference for the examination. He refers the application, he refers the claim to be assessed and gauged by some of the experts which are employed by the patent office for the same purpose. Let us see where does it happen or where does it take place. It takes place under section 12 and 11A, read along with rule 24B subclause 2 clause 1, where the patent controller does have a right or does have a power to refer the matter to the examiners, and he requires the examiners to return back with their investigation or with their analysis or with their examination of the patent application, jotting down certain important information and particulars about the examination of the information, and on the basis of that examiner's report or outcome, the patent controller will proceed ahead in granting the patent to the person who is an applicant in this case. Once a request for examination is received and the application is published under section 11A, the applicant is taken up for examination in the chronological order of filing of request for examination, and the patent application is referred to an examiner by the controller for conducting the formal as well as substantive examination as per the subject matter of the invention vis-a-vis the area of specialization of the examiner. I mean, the one who is the domain expert of that particular subject matter will be handed over with the application or with the claim to examine that application of the inventor of the applicant, and that examiner will revert back with his findings about the application, about his novelty, about the inventive step involved, about the utility of the work, and about many other things, whether it is subject matter or not. Well friends, at present the patent office has 4 examination groups based on the broad area of specialization. That is how the controller or you can say that the controller basically refers the matter within these 4 groups, or to the experts of these 4 groups, which are as follows. First, first group to which the patent application for the examination is to be referred is the group of chemistry and allied subjects. Then another group is the biotechnology, microbiology and allied subjects group. They will be assigned with the application examination of the invention relating to biotechnology, microbiology and allied subjects. Then another group is the electrical, electronics and related subject group, and the fourth and the final group presently is the mechanical and other subject groups. So the patent controller will identify with your application, and they will decide to whom the matter is to be referred by seeing the subject matter of the claim of your invention. When they are satisfied that your work belongs to, say, one kind of a claim belongs to one kind of a subject or one discipline, they will send the same to the expert of that discipline for the examination, and that expert, who is called an examiner, he will revert back his findings to the patent controller, will let the controller know about the discrepancies if there are any, or will let the patent controller know about the quality of the application filed by the inventor or the quality of the invention seeking patent protection for by the patent applicant. Well friends, when this part of getting the work examined through the patent examiner is done, the next thing that is a very important part or the process of obtainment of the patent is about conducting the prior art search or conducting the search of the anticipation of the previous publication. That takes place under section 13. Section 13 of the Patents Act 1970, it does what? This section 13 gives the power to the controller to go for the search or allow the examiners to search for anticipation against the previous publications or prior claims. The examiner does what? He conducts a search in the Indian patent database. Starting from this date, we have a database as shown on the slide, that since the year 1912 we are having a database for the patent, and from that Indian patent database the patent examiner will conduct a search. If he finds any work resembling your claim or any work which is discernible to the person ordinarily skilled in that art, in that case they will jot down the findings or record the findings in their report that this work is already lies in the prior art or kind of a anticipated work or maybe a prior claim made by somebody somewhere, and the examiner may conduct this search on other databases of the countries like European Patent Office database, then WIPO, World Intellectual Property Organization database, US PTO database, which is a huge database friends, United States Patent Trademark Office database, then JPO database, Japan Patent Office database, TKDL Traditional Knowledge Digital Library database and other paid databases. So on assessing or while assessing the patent application, especially on the grounds of section 13 or on the requirements of section 13, there are several databases to be referred by the controller through its examiners or through his examiners. They refer to the Indian Patent Office database, they refer to the JPO database, they refer to the USPTO database, they refer to EPO database, and they refer to the Traditional Knowledge Digital Library, and some other paid databases are also available nowadays with the patent offices. So all these databases are to be referred, and the conduct of the prior art search is done making these databases as base for researching and searching the prior art or the claim or the anticipation. When the controller through the examiners is satisfied that this particular claim or this invention over which the patent is sought is a invention or a claim which does not appear in any of the database as a anticipated work, as a prior art, or as a prior claim, then the patent controller gets satisfied and he proceed ahead with further formalities of granting or conferring the patent to the applicant. That is how the patent is granted. I mean, there are several things. Then see, this search is conducted to find out any publication which may anticipate the claimed subject matter. And as we have discussed the requirement of novelty in my previous discourses, so I presume and assume that all my viewers understand that by conducting this search, what is to be tried by the patent controller to identify? He tries to identify whether the work is novel, whether the work is qualified on the substantive requirements of patentability or not. If he finds any work in the prior arts, or I mean in the databases as mentioned above, in that case the work may not be novel, may not be involving an inventive step, and that is why the work will be denied the patent protection, will not be granted the patent protection. Another objective of this search is to ascertain whether an invention has claimed in any claims of the complete specification, has been claimed in any claim of any other complete specification filed in India, which has been published or after the date of filing of the applicant's complete specification. So they determine whether the same application or same kind of a claim has been earlier made or not. They ascertain the novelty in it. Well friends, that's all about the procedural formalities or procedural aspects for obtaining the patent. I would like to recapitulate certain important points for all my viewers that would be takeaways for them for today's discourse, as well as the discourse delivered by me yesterday, that there are 4 things to be taken care of by the person seeking the patent protection: who is eligible to file the patent, where to file the patent, when to file the patent, and how to file the patent. We have discussed elaborately, elucidated all the patent rules and patent sections or provisions mentioning or talking about the procedural formalities in detail, and I believe that now all my viewers are in a position or maybe in a capacity to file the patent application or get it filed properly by referring to these various provisions of the Patent Act 1970 as well as Patent Rules 2003 and some of the forms as highlighted by me and shown by me in my discourses or during my discourses. So I wish you luck for filing the patent application. Thank you so very much. Thanks.
With this note, thank you, sir. Thank you so very much for giving us a very productive session once again. And dear friends, we would like to tell you all that we are done with the procedural requirements for obtaining patents in India. This was the second lecture. If you want to access the first lecture on the procedural requirement for obtaining patents in India, then definitely you can access it with the help of the YouTube, as we have already uploaded that particular lecture on the YouTube. This is for your convenience so that you can watch the 2 lectures in series in chronology, so that it becomes convenient for you to understand the topic as a whole. And very soon we are going to upload this lecture also, and after that, if you feel that you have any queries or if you want to give your feedback, then you can mail us at info.cc@nic.in. We would love to solve your queries. We would love to answer the questions which you would be mailing us. The next time when Mr. Ashwini Sewal visits our studio, we would be meeting again with another important topic under the series, General Course on Intellectual Property Rights, very soon. Till then, take care. Goodbye. Thank you, sir. Thank you so very much.
Thank you very much.